Hey guys, how you doing? Today is April 28th. Coincidentally, it's day of mourning for persons with WSIB, persons injured or losing their life on the job. And another one of the, I'm one of those persons. And it's also about the system we're left with. System freedom for free, why are hands tied? Anyway, this is an update. So as you can see, set the sign out, still showing the property. Things are still the same. Well, not quite. Things aren't the same. They've gotten more desperate. So here it is, April 28th, 2021. Just to let you know, the rental license bylaw states that it's unlawful for any person to cause to be collected or to collect rent for any property that does not meet the minimum standards, including all bylaws for the region. My situation has been explained many times about that. There's an outstanding work order still in place for 100A, and again, they made a mistake and included the fence for 98B. But the fact remains, it still is not to code. It was part of the work order that says that it wasn't to code then. It was supposed to be satisfied June 15th, I believe, or 19th of 2019. The rest of it's there. Anyway, the point that we're trying to show is this. I want to simplify it for you. Basically, you have the lawyer for Waterloo. You got city council, and that goes to council, all the members and that, and everybody gets together and they sit down, they work out through committees or whatever else, research or whatever, to come up with these laws, bylaws, provincial laws, whatever other laws that are there. And they're meant to protect us. And they come up with these laws, they spend a lot of money getting there, and all of a sudden they formulate the law, they write it up, they pass it, they ratify it, and the lawyer that represents the corporation of the City of Waterloo and or Region of Waterloo and or Province of Ontario signs that document to say that that is a legal and binding document which is there to protect the rights of the taxpayers and the persons of Waterloo. All supposed to be equal, disabled included, and all this other stuff, especially when the rental bylaw was specifically designed to, the promise was that it would reduce costs to make sure that landlords are, and the system is more conducive to making sure that landlords and owners are responsible for the upkeep of their places, which has been an ongoing situation in the region for a long time. This is all Ministry of Housing and Municipal Affairs. They're acting as a prison system. It's a systemic prison system. And that's what this exposes, because the law is ratified and signed by the lawyer. And then on the other hand, the lawyer goes out as a solicitor for the region of Waterloo, or for City of Waterloo, Region of Waterloo, Province, whatever. And they solicit business on behalf of the city or region or province or what have you. And they get into development deals, like those apartments that have been popping up everywhere, residential tenancy places. The business formula being that you have banking and financing, insurance, everything sewn up tightly into the development and planning deal, to the point where they have a developer. In this case, I haven't been able to get the exact information because they've been keeping the public record from us because of what we've uncovered so far. And again, even asking as accessibility as persons with disabilities, but because of the content, they're preventing it. So part of this is we are asking everybody to go, hey man, if you agree with us, we need to have that public record open to say what's the development deals, because this is what they do. They have banking, financing in place, insurance, because they have a contractor in place, somebody like Coupa Marcoux. I say that just from general information as an example, not knowing that it might or might not be involved in an actual development deal here, because we've been unable to get that information as a public record, and actually have been obstructed from doing so. Regardless of where we go or what we do or how many times I write it down or put it or post it up or whatever. Anyway, so they're making these deals, and they have a management company such as Atlas Property Group, Waterloo, or Koenig Holdings, which for public information you need to know is the same thing. Mark Koenig of Koenig Holdings reports himself as the Chief Financial Officer for Atlas Property Group, Waterloo. So I guess when things are good, he's Atlas Property Group, and when things are bad, he becomes Koenig Holdings. Either way, the person is the same, but it goes again to talk about misrepresentation. So on city level again, you've got the city solicitor making these deals. Then they sign the contracts with these people, and what it looks like is happening here is that they are using judicial privilege, misusing, abusing judicial privilege in order to cover any act or action that they do. The problem with that is that they are required to act lawfully at all times. All persons are, including us. If they are acting unlawfully, they cannot make a decision based on unlawful acts, especially when it's blatant like this. They can't use it as a blanket immunity in order to sit there and say, well, yeah, on one side, see, we're protecting you. We've got these safeguards in place that when you try and enact it, they obstruct it. Because let me tell you something, the one thing you need to understand about this work order is this landlord has never been charged under the rental license bylaw. He's been charged under the property standards bylaw. The problem with that is under Municipal Act and also under the rental bylaw that if you are infringement of one bylaw, it's the same circumstances that infringes the next one. So they can't just sit, but it shows their misrepresentation, because again it states no person shall misrepresent or give false information. Person including corporation, including the corporation of the City of Waterloo, corporation for the region of Waterloo, the corporation for the province of Ontario, etc., Atlas Property Group, etc. That's why when they posted after failing multiple inspections, even though they misrepresented on all forms, through Municipal Act, that it was true to the best, that it was true. All records, if you go and you follow the page, the records are there. You need to go to the description part. The links are there to the actual public records we uncovered. Documents that were filed with the necessary people. They just dismissed them. Even as a regular person, they're not allowed to dismiss them, but anyway, the point is this. Supreme Court of Canada has already ruled, based on a case brought in British Columbia, that if they use judicial immunity in bad faith meaning, like I said, you can't make a law on one side and then undermine it directly on the other in order to provide a whole bunch of lack of services so they could spend taxpayers' money improperly. Again, we are asking for full inspection on these properties, and this property especially, because in the marketplace, it's $450 for an inspection. Anybody can go out and get an inspection for a residential if they own it. But a tenant cannot go and get one for his residence, because if we were able to do that, we could take that de facto, it would be done. We'd pay $450. This would have been done years ago, properly, even though the law dictates they're not allowed to misrepresent. They're not allowed to do anything but their full job. And there's more than enough proof of what's going on here, because we've gone to Human Rights Legal Support Center. We've gone to every avenue in Canadian and Ontario law. And all you're left with is the people who represent legal aid. And they've been making this mess for many years, and all you have to do is go to their website and see how much, Minister of Finance, see how much money is invested in legal aid services and independent living services, stuff like that. But they are prevented from actually helping us. They can only refer us back to the same system. Arch Disability Management and them have come up with a way to manage disability. But irregardless of that, the facts remain. They are not allowed to use the law to overrule the law, especially in this context. That is bad faith under the action brought by the Supreme Court of Canada by BC. It was stated that if they act in bad faith, there is no immunity. So it's up to you. The evidence is there. We invite you to look at what we posted. We've documented this over the last few years, and had we not done that, it'd be their word against ours. To sum it up, they tried an ex-party, like while we're trying to go through human rights, and they're trying to fight us back on this, because all we're asking for is somebody to help us write it down the way it is, our case. But they refuse to, because they are implicated. And obviously they're not going to, there's nothing in the system. I even went to Pro Bono Ontario, and they have nothing. Nothing. All they are, again, Arch Disability Management, that's it. Circular, it's the Crown. They're using the Crown rule in order to overrule and con the public, because here's the significance. By withholding the lawful work order, which is not being enforced, this property at 100A has been, it should have had, they do it at $350 a day based on what the work order is now, but if you include property rental bylaw, it's $850 a day for every day or part day that it remains unfinished until it's completed. And it's still not completed. Matter of fact, they created another new hazard, which is they removed the fence that was at the end here, because the fence was put in there originally because you're not allowed to have more than a foot drop without a guardrail. So the fence, the stairs are probably right if they're done properly to code, but what's not to code is they are supposed to, from the stairs, first of all, have a handrail going down the stair, and it's supposed to have a guardrail over to the edge here. That is current bylaw, and this is what they called corrective measure. Okay, they called that corrective measure. Matter of fact, they haven't checked it at all. They just let him do what he did. The significance of which is this: they just made it look like what he filed, even though what he filed isn't correct. So it's just making it look good on paper, right? Anyway, here's the thing. We've got them all in this. I wrote the letter. You can see it. October 30th was sent out to all the parties and properly identified, including the finance minister, because again, by withholding the proper lien against that property is now has a potential lien of over $850 a day for every day or part day that it remains undone. And what they've been covering up for landlord or whatever else, that's between them. They can sue each other. But as far as it comes to the taxpayer, what they're required to do under law, this is taxes that, this is, I would say, between fines and taxes and liens, which are required to be covered as taxes. Both properties are included because, again, I said, let me show you. And it's posted in the work order. They made it, they're so arrogant and so full of themselves that it doesn't matter what they do, who they heart, whether they're following any laws or not, they just make it up as they go along. Because, as I said, this fence here, this side of the fence, right here, sorry about the grass, I'm trying to get it growing. It's too wet back here. But anyway, this fence is what was included in the work order. And here you have it. There you have it. Is that fixed? It's rusty. It's supposed to be replaced or fixed as part of that work order. It has not been fixed. It has not been repaired. But the problem is, here, let me follow the fence. Goes to that fence. Now notice there's no fence there other than that part there and this part here. So the fence is actually here. This is the fence for 98B, always has been. They ruled it on the work order as not being the code, only in context of rust and repair, not in context of the proper bylaw. Not to mention the landlord owned both properties at both times. We are requiring a full inspection on both properties. It is clear they have used this as nothing more than a means of harassment. So, I'm going to wrap this up with a fact. They tried an ex parte order. In spite of our efforts at every venue to have this brought forward, Tony Bruto, the head of Southwestern Ontario, was actually sitting on the board that day as chairman, corralling everybody into their little pre-arranged little situation, their cookie cutter world. And we didn't get notified of the order, of the action at all. And the interesting thing about that is that they're not allowed to have a hearing or anything because it's supposed to come directly from the landlord-tenant board directly to us if there's a hearing or an action at all. We received nothing from them whatsoever, and which means ex parte means without notice. So we had absolutely no notice, but they tried to pull a fast one because we were doing a water heater repair here. And in the emails that they sent, because they have to sit there and make it look like they did the right thing, their representative, Lisa Nadon, sent documents as an update, which were an update for this action. And she had to send a copy to us, so I guess she tried to hide it in the business with the water heater. Anyway, I took a look at it, and I looked at the documents. That wasn't anything really, like I was like, what's this? And I went up to the email header, and it said SW, in relation to file SWL, whatever the number was, and meeting April 22nd, 2021. And this was April 21st that I got this. So I immediately went, what's that? Just because of my knowledge, I went to the website. You can go to the website and you can punch in that SWL number, and they'll tell you the status of the claim. I had checked against the other numbers we had received. We had not received anything on this at all. They actually did this filing on, it was posted October 15th. We had a hearing November 4th that they did not show up for. We sent in all materials for, and they just didn't bother having the hearing. But they received all materials as an answer to their filing. Because the whole point here is not to have anything that we file actually filed. Well, they got caught. Because I found out the hearing time and date. I went online and we attended the hearing. And totally surprised the shit out of all of them. Especially Mr. Bruto. Now the thing is that we asked for assistance through their disability department. Accessibility. Nobody contacted us ever. That's why we had to go to Bruto. That's why we had to go to the Minister Clark. That's why we had to go to other people. That's why we've been going everywhere about. Go watch the videos. They were informed. We were sent through to hearing with Miss Edu, EDU, and she said something interesting, because right away they weren't happy we were there, so anytime I tried to speak, they just tried to shut it down. They immediately tried to shut it down. She was interruptive, argumentative, like she'd ask me a question, the minute I say 3 syllables, she'd start talking and saying I'm talking over her. So I would, anyway, it's documented. And because of my disability, we recorded the whole process. So they sit there and they're worried now about people recording, but they've been well informed that we record. I record for my disability, and based on my disability, I don't have to wait for their version. We'll get it anyway to see what the comparison is, because I guarantee it's not going to be the same. But the interesting thing about Miss Edu is that as I was trying to speak, and we were saying, because I looked up the rules for adjournment right away, and this definitely applied for adjournment. Of course, Lisa Nadon was dead against it. She was really worried, though. You could hear it in her voice, because they were not expecting us to show up. They wanted to do an ex parte order where they had an eviction order, and it wouldn't have been exercised right away, but they would have had the full eviction without having to do anything for it, even though the Landlord Tenant Board and Ministry of Housing have been more than made aware of what's going on here. So anyway, we get such through the hearing. It ends up that I try to say, she asked who I am and the representative, blah, blah, blah. And we had Kerry Mills there. So Kerry says, yes, he's here to represent me. So now I am officially a representative for the file on record, which we've been trying to do because it's all there with everybody. I have full authority because of my knowledge to represent their legal interest. I'm not representing them legally. I'm making sure that anybody who is based on the law. Anyway, so we got our adjournment. We're on record, but the thing is this, during the hearing, before that happened, I went to talk to her about my disability, and she shut me down. She says, you are not the client. Do you get that? I am not the client, so therefore she doesn't have to listen to anything about disability. Well, we were the client in the original part of this. And again, I will post the documents. You need to look at them. The document, there's a box there. There's always a box there that says, is there any issue that may interrupt what you are trying to put forth here that we need to know about? And they're supposed to put in, yes, there's this, because they've been preventing us from having an official counterclaim. Paper-wise, it looks like, oh, nothing's going on, but they're having problems with tenants that they're getting out because of non-payment of rent. And they were doing this to try to be underhanded, but we stopped them. We are now a matter of record. But here we are. Okay? They've acted unlawfully. The landlord has acted unlawfully. The police have arrested me. We can't even go to the police about the fraud because Mark Koenig is the CFO of Atlas Property Group, and as you can see, all we did was we posted a letter, and I will post it again. When they posted the license here, I wrote a letter because of the evidence of going forward, and I said, I'm sorry, it shows that this is misrepresented. The documents you filed about this property are misrepresented, and you have 30 days to fix it or prove it. Or was it 60? I'll have to go back and look. Anyway, they were given proper notice, and they were sent out to everybody, including the city. As far as, anyway, I'll have to look at it. But definitely Atlas Property Group, Theo Papadopoulos, the persons, and everybody regarded. And that's what we asked for, okay? Still not complied with. They are required to do a simple inspection. Market $450 per property. We are prevented from doing so because then the record would be clear. But that is obstruction. We still do, even though I've disabled, I still do all the stuff around here. We are honoring our part of the agreement, but let me tell you something. Because of what's been going on, we have not paid unlawful rent to this residence since August of 2019. It has been held by us. They just made a, oh, sorry, I gotta go inside. Actually, I'll sit here. They just made a ruling in this hearing that we had to pay ongoing rent, even though it's proven to be unlawful. And again, the law is clear that says no person, which includes the landlord-tenant board, any municipal officer, anybody like that, can interfere with the law. That's what the Municipal Act is for. This is the same department that takes care of property standards for long-term care homes, hospitals, everything. Sorry, I gotta go inside. Whoop. Sorry, it's dark here. I gotta turn on some lights. Oops, sorry. Ow. Okay, so let's just start it ready. Hey, maybe we'll get to see the rain coming in too. Oh, anyway, sorry. Sorry about that. There, let me show you. So again, this is where it comes leaking in all the time once we get lots of rain. This year we haven't had much rain this year, but it's already came in once. I think it was February or something like that. We got the video. Anyway, thing is that they're required to act by the law at all times. Mark Koenig is also CFO, Chief Financial Officer of Atlas Property Group. Atlas Property Group, because we sent them that letter, permanently closed. No forwarding address. They were reporting, I believe, on the Google, it was saying $8 to $10 million worth of business in the last few years or something like that in growth. And because of one document, because the implication is that every document that they signed should be looked at for accuracy. Because this one definitely is not. And it didn't match the drawings even, because all they're doing is they're just stamping the same old drawing without checking anything. It's just looks good on paper. Again, the thing that we uncovered is that the city was well aware of the property changing hands. This property here has a history. 98B has a history because it used to be one of those properties with like 5-6 rooms at like whatever they were charging a room. Just before it was sold, it went back to that for a little bit, but before that happened, they didn't have a furnace. They had to replace the furnace. And everybody was kicked out for safety reasons. And they supposedly fixed the furnace, and then they went on. So the contact with this property is well taken. It's very simple. You do a simple top to bottom inspection. You hand the results, they have time to fix it, and they fix it. That's a responsible thing to do. To do anything other than that is to undermine the whole system and act unlawfully. Even though they're acting unlawfully, they use that as a means to exacerbate my symptoms, to use it as a means of what the International Criminal Court terms as psychological warfare upon the residents. And it's just like, you're not going to make me, because we got this judicial privilege. I can do whatever I want, including human rights. And that's what human rights sent back as a response, was that they have judicial immunity. Not when they're acting in bad faith according to the Supreme Court of Canada. Anyway, long and short of it, we're getting 25 minutes now. This is just to give you a bit of an update. On top of that, they're also communicating, because I'm going to post a different video telling you about my challenges for health. Sorry, I'm trying not to put my face right in it. Anyway, I guess I got to put it this way. Kind of fading now too. But have to do an update on health, because they are blocking any and obstructing any kind of challenge to there's anything wrong with the healthcare system either. But I was literally almost assaulted and then almost blackmailed at my one doctor's. They told me, oh, well, just go write it down. Go complain. Which again, as a person with disability, even though I'm able to write things down and put it together, it takes a long time. And what's your definition of hardship? Like, I got nothing better to do than this all day, when I shouldn't be doing it all. I should be doing what I need to do in my life. Security person, right? Anyway, so I'm going to do an update video on that. But 2 clinics I went into for actual help, and because I guess the second clinic turned me away because of the first clinic. It was really interesting though. Anyway, I'm going to put up another one. But again, who do you go to? I got to go write it down on a website somewhere, and then somebody will get around to it, you know. But you know, here we are as a private healthcare, and I'm starting to wonder, because right after that happened, as this is happening, they know I'm having a bit of a health crisis here and health issues, and all of a sudden, out of nowhere, this Exparte thing happens where we accidentally found out about it, and we're able to get our 2 cents in. I'm not sure we stopped anything. They ended up hanging up at the end, because they were so, I was asking, hey man, if you're supposed to send it in mail, we never received anything, we all checked it, we never got it, that's a matter for police. And yet they, like I said, they don't want us speaking. So she was threatening me and stuff, and she ended up hanging up. So I don't know how it ended up being, but we have it all on recording to cover our ass, and they were perfectly informed beforehand. If it wasn't for us documenting this, there would be no evidence. We are asking the public to get behind this for 2 things. Number 1, you need to get in touch with Doug Ford, Minister Clark, Mayor Jaworski, Karen Redmond, Ian Kerr, whoever you need to. I will put direct links to them. And tell them, number 1, we demand full property inspections on these 4 properties. At least on these 2. Because the one with the work order, that was not a full inspection. They just went to make it look like the paper and address what I had brought up. Because it's a subterfuge. It's a misrepresentation from the beginning. And again, no person means the corporation. No police officer. That's you, Brian Larkin. You cannot support an unlawful act. And the landlord and others are acting unlawfully. And we demand a full criminal investigation. We demand full opening of the public record with regard to proper planning and development contracts in the region. Like this, because it appears that they are using their judicial immunity to circumvent the law, to overrule the law, to overrule their own lack and objection to basic due diligence. Without basic due diligence and adherence to the law, there is no good faith. And anybody who supports, and we have gone to everybody with the public record, with the actual things, and the landlord next door had the rent for June. We were kicked out for not paying the rent for June. The reason why he didn't do the rent for June is because he was illegal with the work order until they gave him the letter, and well, it's all posted, till they forgave him. But at any time he could have cashed that check for June, like he did every day or every month for the 2 years prior to that. This was an orchestrated invented thing to cover up their crimes. Go watch for yourself. You're supposed to trust the fire department. They are municipal inspectors. You're supposed to trust the police. They are municipal officers. You're supposed to trust municipal enforcement inspectors. Well, it's in their name. You're supposed to trust city employees, which are actually municipal employees by, municipal is the crown. Municipal is, we do what we want. And in this context, are they allowed to decide, well, we're going to be really hard on people because of COVID, but this landlord, who now because of that work order, we say potentially owes over $1 million in taxes and fines just for these two properties based on what they should have been fined. I think even at $350 a day based on the one. And it's clear that offense is for this one, which means just because they didn't do it properly, again, it shows this needs to be reviewed. And Minister Clark, you are responsible for old age, long-term care homes, all public buildings. I am a person with a brain injury who has documented this over since 2004 because of my brain injury, more or less. It's time we end this. We need to have, and I invite any taxpayer to join us in a class action against the city. Because again, there's no immunity if they are breaking the law. So anyway, either way, we need public support. I'm not doing good. This pressure has been unbelievable. Anyway, I'll make another video about that. I want to keep it short and sweet. But we need your support. We need you to get in touch with the powers that be and tell them, number one, we need inspections of these properties now. And they stop all action against us until they get it. We got a little surprise for them coming anyway, as far as that goes. But I mean, we're not getting their cooperation. And after the ex parte try like that, I mean, this was an underhanded sideswipe, and that is an automatic human rights case. This is systemic. Human Rights Legal Support Center, I'm putting out there that if you get advised by anybody from Law Society of Upper Canada Legal Support Center, it's not the lawyer. The lawyer is prevented from telling you anything other than what he is telling you, even though the law is clear. They do not represent you. They represent keeping the lid on what's going on. And this pandemic only exposes the fact that they're only interested in money. This is a banking, this is what they mean when they say open for business. This is their business plan. Predetermined, under contract, fully financed by the banks and government. But here's the question. Are banks and government not required to follow human rights law? And if in an environmental assessment, they have to look after salamanders and turtles and etc. You'd think that in their policies that they make, that they're required to follow human rights law, and that would apply anywhere they are in the world. The thing you need to understand about Canada is, if we're so free, why are our hands tied? And this is what it means to be disabled in Canada, notwithstanding. That clause needs to be removed. And this is the crown. So we are looking for anybody to help us compile the proper information in the proper form, so it's not totally grossly, we don't need all of it. We only need certain parts of it to demonstrate. And we need to put this case together to have it filed with the tribunal, because that is the body that decides, not these human rights lawyers and this facade that they put up. They did this to me once before, and I asked them this time, I need to have that information so that I could make my complaint. And they just, like everybody else, just don't respond, and they do what they want because they're covered by immunity, I guess. Anyway, every taxpayer, full inspections for these properties. Open the public record, and we need an investigation into how they are designing these planning and development deals for these high-rise apartments. how, again, by withholding the work order, they are withholding a proper lien against that property, and right now they may be negotiating with those banks in order to give a false evaluation, which will now become a loan for a development deal, which now becomes part of the tax burden, when instead it should have recovered that amount in taxes, and even more if you include more than these two properties. He certainly demonstrated 2 years prior. And again, the fraud was, we had a license posted up there when we saw the place. It looked like it was licensed. He gave us his Kupel Marku card, not his Commissions Worldwide Inc. card, which is his private company. There was no reason to think we had anything to worry about when we negotiated a fully binding lease. And Carrie and John did too, for this place, as any other person who enacts a proper lease. Anyway, municipal affairs and housing is connected to it all. It's a systemic prison system. It's only their opinion that matters. And hey, at least we're all included, eh? Because the other thing they said, interesting at human rights, is that there's no discrimination. And if you think about it, the way they got it set up, they're right. Because they're treating us all the same way. And with this, if what we are saying about this planning and development, open for business scheme they got going here, and I bet you it's in every single jurisdiction where the Commonwealth exists, including Australia. Look at the links. Condo developments, everything tied to Municipal Act, which you cannot fart in this country without having a municipal inspector smelling which way it came from and what you ate for breakfast. So ask yourself, are we free? Anyway, we're free to demand those inspections. We ask for your help. And like I said, anybody, hey, maybe you're retired. Maybe you don't have to worry about your license. Maybe you can finally actually take the law the way it's written and go, hey, here's one for everybody. But the action is against Her Majesty the Crown and Right of Canada and everyone under that. And again, like I said, hey, I challenge anybody in the legal system. Where do we go? There's nowhere. Anyway, looking for your help, looking for an update. I'll give you the one on my health in a bit. I hope everybody's safe. Be well. It is what it is, guys. And like I said, this pandemic just uncovered the fact that they're only interested in the money. And with the banks and government working hand in hand under the guise of judicial immunity, I guess that kind of shows why they're foreclosing on all these long-term leases in business centers that are now worth a lot more real estate, and why they're turning tenancies into upscale residential properties and condos and stuff, because it's about the reset, the great reset, right? But the biggest thing being, again, the insinuation that if they are preventing the true value, which means that property next door is worth nothing. Matter of fact, technically the city owns it. The taxpayers of Waterloo owns that property, not them. And yet they're going to go to a bank, or already have secured a loan for the full false value of these properties. And this is only 4 properties, so where else is this happening? It's a question we need to ask, I guess. Or maybe not. What, am I just another Karen? I don't think so. This is the most important human rights case there ever was, and they're scared because for them to step over that bound, it is clear what they're doing now. This is a human rights case, and I'm going to try and bring it to myself, if I have to the Human Rights Tribunal directly, including my complaint against the Human Rights Legal Support Center, because again, no judicial immunity if you're acting in bad faith, even if you don't know it. Anyway, we need help, we need support, and I hope I live through this. Be well. I hope you're well. Stay safe. Protect each other. Document and look for yourself for the real truth, not the fake news. And again, if we are free, why are hands tied? It's all connected to the Ministry of Municipal Affairs, because they are the ones who control the land registry as well. You need to ask yourself who benefits Yeah, I mean, everybody does in a way because mortgages go up, but the thing is, it's a false thing, and they could pull that out from under you at any time, and that's how they do the teeter-totter thing, man. You could be having all your stuff, you could be paying your bills everywhere. Everything's like this, you know. Everybody who pays their bill, you got the ones that can't anymore because they control the whole market, and all of a sudden the teeter-totter goes like this, and guess what? Even the ones up here at my elbow that paid the bills, never missed a payment and all that, they slide down the hill too. Lose their property because they allowed the other end to exist. And matter of fact, I would say they created it. Pay attention. The other thing the pandemic shows is that they didn't even know what an essential worker was. They're still figuring it out. And as far as the quarter goes, I'm almost at that point where I'm going to post that actual call. Because again, John Lichty entered the hospital of St. Mary's and didn't come out of it in July 2019. But the most significant thing is he went in for an operation and he signed on that, or he didn't sign on that document other than the doctor was required to make the decision if anything went wrong. Nobody else. He did not sign permission for anybody else to make those decisions but the doctor, and yet they kept him alive for significantly after, shocking him, giving him drugs, making the staff at ICU go through that trauma, being the ones thinking they're the ones inflicting it. At some point during that process, the hospital St. Mary's staff and or lawyer, legal department, and informed the office of the lawyer advisor that there was a problem. That they noticed that they had been doing this, I guess, because in the context they were doing it, we were out, acting appropriately, trying to get the proper documentation to make sure that it was legal to make those decisions. Not being aware that it had not been signed, because they were acting the whole time that this was a de facto thing. Forcing Carrie Mills to be in this position she never should have been in. And that John Lichty decidedly, because of what he omitted from the record, that she was not, it was the doctor, clearly. And all you need to do to find out is look at that form. Everything else is moot after that. But the point is this, at some point during the process, the hospital and the office of the lawyer advisor got together and they were informed. And there was a meeting called at the hospital, which I attended with Carrie and others. And because of my disability, I recorded, where it was revealed I happened to be sitting beside the woman who had the form. And she, when in the discussion, she literally says, but he didn't sign the form. And that's the first time we were directed to the fact that he did not sign the form to have Carrie make any of these decisions. Documented in this call. The significance of that, they continued days after that. And it was problematic. And the minute he died, we were told to get off the property, basically, because we're not next to kin, officially. And it was treated as a private enterprise. Even when I went back to the meeting to try and ascertain and to initiate, again, using disability against and the whole bit, again, it's not privatized healthcare. But the point is this, we ended up asking for the involvement of the coroner, which they did get involved. I had contact with the coroner on the phone a couple times. The one at the hospital was very peculiar. Well, actually, all of them were. But the end result was they were trying to prevent us from having anything done. We informed that we wanted a coroner's inquest, like coroner to look into it. She wanted an autopsy. It all ended up being they went looking for the next of kin and that. They found them. Next of kin agreed to the autopsy, I guess. Either way, he was slated to go to autopsy. They held him beyond, I mean, even the funeral home was saying they had never seen it in the many years they've been in business. But he was withheld. We found out at the funeral home that the next of kin, when we got together to take care of him, when we finally got his body returned, sometime later, that the coroner representative or somebody had counseled her to allow them to cut out the heart and only send the heart for autopsy so she could have the body to bury him. And thank God she's Catholic, and it puzzled her why, but she revealed that, and she said that that was puzzling. But anyway, they were prevented from doing that, so he was done full autopsy. We had reported to the police. We went into the police and we had an interview. Carrie, myself, and I can't remember if Denise was there or not. Anyway, but I think she was, because she was a witness too. We were all witness to the events that happened. And we had reported it. We went in and reported to Waterloo Regional Police. They took our information, and we've never heard anything more about it. We've been sidetracked with this to be able to even look for the public record, but that should be a criminal investigation. And in spite of all that, and that was in all of this that happened, where Carrie's been under assault with that too. And this is just continuation of the original assault. But the bottom line is this: they have to act lawfully, and the law says minimum standard inspection. Please help us start there. And we're looking to, if we need to, bring a civil action to whatever level of court in a municipal act to force them to do their job. You know, force them, bring this forward and have them do these inspections. There's more than enough information to say that these need to be done, and that there's this unlawful pushback against it. Anyway, we hope you help. And in the meantime, thank you. I hope you're well. Be well. Stay strong. Try and create rather than tear down, destroy. Be COVID safe, and we'll talk to you soon. Thank you.